So, tiny little bit there about Shorebird. We'll move on to workplace stress. And the first question, so I'm going to open that up now. So, Adam.
Well, hello everyone, and it's on behalf of the three barristers with you today, Paul Wilson, Paul Smith and myself. It's our pleasure to come and do this Q&A session with you. As Liz said, we are, just to give you a bit of information about us, we're barristers specialising in employment law at Broadway House Chambers, and we're based in Leeds and Bradford. Now, what we thought we would come and do today is come and answer your questions that you have about stress in the workplace and disability discrimination. Now, I have to give a short disclaimer. It was on the slide just before that Liz has just put on for you there. Any matters discussed, any opinions put over today by the three of us, it doesn't constitute legal advice because, of course, we don't know the ins and outs of your particular problem. So anything we do say isn't legal advice, and obviously no liability is accepted for it. So that's the lawyery disclaimer bit to get us started. But what we are happy to do today is to speak to you about general issues you've got. Any questions, please do start typing now. If you have come here geared with any questions, pop them in the questions box, and we will tackle them as we go. But we can move on to our first sort of issue: what can be done to support people in reducing their stress at work? And what I'm going to do first of all is open it up to the two Pauls who are both sat in our offices over in Leeds, and let them say a bit about some general advice as to what can be done to support people in reducing their stress at work. And as they talk, do please pop your questions in the questions box, and we'll tackle them.
By all means, Adam, I'll pick up the thread from you.
Okay.
Just looking at it from the point of Paul Wilson speaking, by the way, everyone, to distinguish rather confusingly two Pauls. Just looking at it from, as we must, from a management point of view, probably some of the things I'm liable to say are things that you will already think of, but I'll put them out there anyway. I mean, it seems to me, in terms of reducing stress at work, first of all, it seems to me the most important thing is to train managers to be aware of the issues that can arise in relation to the creation of stress at work. And of course, we must remember that what we're talking about is excessive pressure being placed on employees. And what I mean by that is it's extremely important, it seems to me, for managers to be trained to spot the signs of stress and to put in place, I think more importantly, the mechanisms whereby they can do that. So what I'm thinking of, it's normally the case that you will have one-to-one meetings. Make sure that those take place with employees. I mean, most organisations, large organisations, will have formal or informal one-to-one meetings between manager and individuals who are to be supervised. And it seems to me that's got to be extremely important to make sure that those meetings take place. And further to that, and I think particularly in the context of stress at work, one thing that I notice an awful lot coming up in employment litigation in the tribunals is that employers, and I appreciate that in the rush of work and all the things that can happen at work, it's often difficult as a matter of practice to do this. But how often it is, the thing that concerns me is how often it is the case that employers fail to follow up and have return to work meetings with employees who have been off sick with stress-related illnesses or just illnesses in general. It seems to me that is the prime time for employers to, through their managers, lend a sympathetic ear and find out what's going on, what may be underlying an employee's absence from work, and indeed whether it is related to stress. I mean, and I must say I'm often surprised by how often that employers fall by the wayside on that front. So my tip really would be to ensure that your managers are trained to be aware of the issues, and I think the broadly speaking, the indicators that may give rise to stress-related problems we all know are change of workload, change of management personnel. I think those are the two things that really give rise to can give rise to excessive stress and lead to further problems. And further to that, as I say, also personal problems that the employee may share with the employer. And as I say, one-to-one meetings and return-to-work meetings, it seems to me, are the forum for that. I mean, I can go on. I think just some other broad considerations. Would it help to do that? I think.
I think if we'll draw on those in a moment. This is Adam Willoughby again, and you'll see on your screen a poll which you've all been participating in as Paul's been talking there, and it's about occupational health reports, and many of you will have had experience of either commissioning the occupational health reports, and some of you may have even been subject to a report itself, and that really is one of the key acts you can do as employers, as responsible employers, is get early input, and it's rather heartwarming is probably putting it a bit strong, but to see that so many of you, Lizzie's just going to broadcast the result now, but 29 of you have said it's false, that it's the end of the matter when if an occupational health report says someone's not disabled, and that's really good, because of course this is whenever you have an individual who has been ill or that sort of thing, it's really important to constantly monitor the situation. And just because you get a report which says, well, I don't think they're disabled, disability it's more of a legal question, and you take into account the occupational health report, of course, but it's not the be all and end all. So a top tip is to get such a report, but don't treat it as the last say. Paul Smith, would you agree with me on that?
I certainly would, and in fact it reflects a judgment from the Employment Appeal Tribunal from last year, or 2014 at the very earliest in any event. But occupational health reports do serve a useful purpose, other than that, as I think both of the chaps have already touched upon, and that is that when you're looking at the various strata within a business and the various layers of management, it may well be that either there's a perception that it's the fault of management, and we're going to come on to discuss that, or that it's somebody's own personal problems and out with the business. Well, it may be a combination of both. As I say, we come on to that. But not only are occupational health reports useful for looking at what the employee is going through, but it's also useful to look at where there might be pressure points from your manager. Because a problem involving one person may, without proper attention being given to it, escalate into a problem involving a number of people, and possibly more than one manager. So the stigma that may be perceived with people being referred to occupational health is something that really ought to be dying a death. They assist the employee, they assist the business, they assist the manager, and they do stop, as far as they can, things escalating out of control to where it becomes a problem that you can't control.
Yeah, absolutely. Do any of you, just feel free to type in the chat box, do any of you have sort of a negative view of the occupational health process? Because I know in some cases I've done, employers have said, well, it's such a difficult process to go through, because the referral forms are quite extensive and sometimes the reports aren't helpful, those sorts of issues. So do feel free to type away if any of you have experienced those sorts of issues, or how helpful you may have found them, and it'll be interesting to see your response. So Jennifer, you've put you found it helpful, and Lisa as well, you referred staff sometimes seem pointless. Yeah, sometimes it is telling you what you already know. I suppose it's one of those things, is with litigation you like to keep a paper trail, and as barristers, when we come to it, and if there are disability issues, it's really key for us to see that you've at least made the referral, because it shows that your willingness to deal with this, I suppose.
The one benefit, it seems to me, is not just an occupational health report telling you where you're going to, but telling you where you've come from with this employee. It's often what renders an occupational health report meaningless is, well, the state of play, this is what we think should happen. But that doesn't provide any understanding at all to how you reach that point. And it's that understanding that is the real key to ensuring that a problem does not get out of hand, and ensuring that the stress in the workplace is being managed appropriately.
Yeah, and I've just seen on the chat box, Vicky Mallows has put there, and thanks for that, Vicky, that sometimes you have to be prepared to challenge some vague, meaningless reports, and you do, and that's absolutely right. And as employers, if you want to probe into or ask probing questions of the occupational health therapist, then that's really sort of helpful and
Could I come in the back of that? Sorry, Adam.
Of course.
Could I come in the back of this? One further point I think it's important to make in this context is that what often happens is that in the occupational health referral form, the occupational health physician will be asked something like this: do you consider that the person meets the requirements of being a disabled person under the Equality Act? And often the occupational health report will come back with a sort of summary of what the illness, shall we say, is, a brief one-line view along the lines of I do or I do not think this person meets those requirements. And I notice very helpfully that often occupational health physicians add, and it's a management decision. But I think what I want to highlight is this, and I note, and it comes off the back of the poll, because I was a little bit surprised to see that 100% of people thought if your occupational health advisor comes back and tells you a person is disabled, that's going to be enough. Because I think what it is very important to stress is if you simply rely upon that kind of one-line answer, you're creating a potentially huge pitfall if the occupational health advisor comes back and says, well, I don't think the person's disabled, and then it turns out further on the line that they are. The point I'm making is employment tribunals and the law expects the employer to consider the definition of disability, i.e. A substantial long-term effect on the ability to carry out normal day-to-day activities, and for the employer to form a judgment on that. Where if you're just relying upon a line in an occupational health physician's report, you can obviously see that's going to create potential problems. So I think it's important, no doubt everyone will agree, to emphasise that point, Adam.
Yeah, absolutely.
In fairness, we did have one dissenting voice that thought it was okay, but we'll gloss over that.
Okay, let's move on. So that's what can be done to support people suffering stress at work and reducing their stress. Let's move on to performance issues and stress at work. Do any of you, feel free to type in the chat or the question box as you please, any of you that are currently dealing with performance issues of an employee, don't obviously name the employee, and whether that's linked to stress at work and any problems you've got, and we'll do our best to answer them and go through your problems there. So do feel free to do that, and there's also another poll which will be interesting to have your input on. But performance issues and stress at work. Paul Smith, I'm going to ask you this. Do you come across many cases where there is an individual suffering from stress at work, their performance is suffering, and an employer just doesn't know what to do? And if so, what would your advice be?
Well, my advice would be, first of all, look into how the problem has arisen. This does seem to crop up, and you do sadly get cases where, and it's largely where there is no HR support, I should add. Normally it's HR practitioners that are really on the ball about this and are able to assist their managers. But looking at smaller businesses which, or even one-man band sole trader businesses that don't have HR support or access to advice, quite often stress at work, because stress manifests in so many different ways. We've heard of the phrases like writer's block and things that a person just reaches a wall, at which point they can go no further, they can do no more, and they stop being productive. That's faced with, well, the employer tries to fight fire with fire, and that is entirely the wrong approach to take. The first thing to do is to investigate the problem. Why is this, and that's without doing it formally. I mean, as soon as you threaten someone with a formal capability procedure because they apparently aren't performing as well as they have done in the past or could do, then you're potentially going to make the situation worse. So I think the first stage is to deal with it with kid gloves, really. Speak to the employee in a confidential situation without pressure. Ask them what's been happening, whether it's been at work, whether they're willing to discuss the personal circumstances. If they're not willing to discuss them, well, fair enough. You can't press them too hard. But it may well be that a reluctance to tell you anything about the personal situation is indicative of how this problem has come about. That said, it would be wrong to make assumptions. And this is really where a referral to occupational health and the right questions being asked is the important step to take. But as I say, because stress manifests itself in so many different ways and means so many different things to different people and is caused by so many different factors, including a mix of factors, I think the first thing to do is to speak to the employee directly and sensitively.
I would agree with that, and that's reflecting really Vicky and Eleanor's points in the chat box there. Often you get, and I've been dealing with a case just before Christmas where the employee has found even the monitoring of their work, because the production was quite low, even the monitoring and the performance capability and performance management process stressful, and then they went off sick. So often you may even need to consider, and this is not delving into the realms of reasonable adjustments, because they may not necessarily be disabled. It may just be a question of stress, and we know stress or the symptoms of stress can lead to a disability. But putting that to one side, sometimes as reasonable employers, you may have to consider how that process can be adapted in some way to try and lessen their stress, because if it's, for example, targets which are stressing them out, say they're going through a divorce in their personal life, and it's sort of having any sort of responsibility such as having to meet targets is really sort of stressing them out. Having them attend performance management meetings and that sort of thing can often tip them over the edge. So it may be that an informal chats are the way to go, still documented, of course, but rather than having formal meetings, informal chats. Again, an employee may say, well, you're treating me differently and you're making me feel a bit of an idiot by having to come and attend these things, and your hands are tied to some extent. But I would certainly say look at adapting that. And there is sometimes a perception, and that's reflected in the polls. Lizzie's just going to broadcast the results now of our latest poll. Sometimes employers think this stress is a word that can be easily bandied about, and it is to some extent. It's often, a crippling. It can be a sign of a crippling illness, but sometimes the word is bandied about, and it's used as an excuse for worsening performance, and that's certainly the perception of some employers. But it's important to always have this sort of open understanding that sometimes stress is actually probably a sign of a disability. It may be suffering with depression at the same time. So I think, as Paul said, approach an employee with care and do the best you can. And it may be, as reflecting in Vicky and Eleanor's questions and points there, it may be that you need to just slightly adapt your processes and procedures.
Could I come in with a point, Adam, at this juncture? I mean, I absolutely agree that you need to take a supportive role when embarking on the path of performance management with an employee who is claiming that they're suffering from stress. But just one other point I think it's helpful to make is this: what happens? I guess what the question is, one of the things the question is addressed to, is what happens when you reach that sort of impasse. I mean, as you said at the beginning of what you were saying, I mean, the typical scenario may be you say to the employee, obviously in sensitive terms, well, we've got no option but to performance manage you, and it often seems to be the case the employee will go off sick and they're not communicating, and one thing leads to another, and you end up effectively with an impasse situation. And the question is, how do you unlock that? And what I thought would be helpful is just to remind everyone that one possibility, and it may not always be suitable, is to bring into play the prospect of a pre-termination discussion with employees. As you know, as a lot of you will know, that is, those discussions will be protected from being disclosed in court. And what the aim of them would be to say, well, look, we have to proceed with a performance management because you're employed as such and such, and we expect a certain level of performance from you, and that may result in your dismissal. Hopefully it won't, but as an option, you might then offer a termination settlement, and that might be one way of bringing an impasse to an end. I think it's helpful to bear that in mind. I think also probably helpful to add as well that only applies to what we call standard unfair dismissal. That is to say, cases not involving things like whistleblowing and so on, where you've got an automatic right to protection from unfair dismissal. And also, it doesn't apply to cases involving discrimination. But let's just, confining ourselves just to performance management, you find yourself in an intractable situation. How do you cut the Gordian knot? That may be one solution, pre-termination negotiations to try and bring the situation to an end on an amicable basis. And let's face it, for some employees, that may be a relief to them to escape from what they find to be a very stressful situation. So I thought I'd throw that in, Adam.
Yeah. There's only one final thing I would add, Adam, and I'm just looking at Jennifer's comment here. She had a situation and felt she couldn't win. Quite often it's that feeling of not being able to win that either is the cause or the symptom of both, of a vicious cycle of stress. And we lawyers, we often talk about this implied term of mutual trust and confidence in every employment relationship, and that's there. But an employer should be careful to keep its ears close to the ground, I think, because it may well be that rather than make an employee face a formal meeting and tell them, well, you can invite someone along, look at the chains of trust in the business. Look at who they're friends with, for example. Look at the manager who has the most sensitive style. Look at a way of getting to this person that's in a way that will help them, because in helping them, you're helping the business too.
Yeah, absolutely. Okay, and that leads on nicely actually to our next slide, which is management style as a source of stress. And often, I suppose, you have outside managers come in from a different site, for example, and their management style may be very different, or they may be even brought in to handle a performance issue, and you then have either an increase in stress or a new cause of stress by a different manager or a different management style. Problems faced as you get into the realms of having grievance policies and that sort of thing in place. What comments would you have on that, Paul Wilson? I'll hand that over to you.
Yeah, certainly. I mean, I think this is a really difficult issue, and it's one that I think quite not infrequently ends up in the employment tribunals, because essentially what can happen is you end up having a battle between who goes. Is it the manager or the employee, and who is right? My suggestions really are that, I mean, I think drawing from my experiences when things have gone wrong and have ended up in litigation would be these, that I think it's key where you have a manager who has, let's say, an abrupt or abrasive style, that you have a senior manager who holds respect in the eyes of that employee dealing with the situation with sensitivity, bringing that manager's attention to bear on what it is they're doing wrong. I mean, obviously that needs to be a two-way process, because the manager mustn't be made to feel as if the situation is all their fault. But it seems to me, let's assume that it's the management style. It seems to me that is extremely important. And it is extremely important, secondly, to focus on the particularity of what the manager is doing wrongly, and to, if at all possible, bring about a situation where that manager receives support and training. I mean, all that, I'm sure, will not take anybody by surprise. I mean, just some other things I would add, though. It strikes me that what often complicates these situations is the problem of delay. Because, once again, maybe I've used the word impasse before, but what I think mustn't happen, or which you should try to avoid happening, is a delay in dealing with the situation. I mean, if your antennae are set so that through one-to-ones, informal and an informal grievance process or return-to-work meetings, you're picking up these kind of issues, that it's your cue to act quickly. The longer you leave it, the worse it becomes. Things become entrenched, positions become polarized, and the situation becomes almost impossible to deal with. And I think that then brings me to perhaps a third point I would make, is when you have that intractable situation, what do you do? I'm just throwing out one particular idea, which in my experience seems to help quite a lot, is the idea of mediation, whether that's informal by somebody in-house or by bringing someone from outside the organisation to try and broker some kind of working arrangement going forward that will enable a manager and employee to move forward. Those would be my observations, Adam.
Yeah.
The only thing I'm just looking at the comments here, Adam. We've got Michelle, Vicky, and Carol, who I think have rightly identified that the word robust is perhaps one that needs more definition, because I think it's quite right to expect robust management. But there's a very, very fine dividing line between robustness that is causing stress and is abrasive, as Paul says, and robustness that is generating and motivating your employees. So I'm surprised the poll result seems to be so clear-cut in disagreement with the proposition. But I think it does come down to how your managers are dealing with things.
And look, to be honest, as lawyers, the two Pauls and I will have sat in employment tribunals and cross-examined a manager on why they weren't more robust. If they expect something of an employee and the employee hasn't performed very well, we will say, why didn't you manage in more robust terms? Why did you not make it more clear that what you expected? So you're damned if you do and you're damned if you don't quite often. And management styles differ, of course. Some managers are very bold and will, even in some circumstances, kitchen managers, for example, it's quite common for them to have quite a shouty style. And look at military management in the military. You get very harsh styles. But equally, in other office environments, it may not be as appropriate. So I think it's all about looking at your employees and what I suppose makes them work best, and often you need, as it was identified in the chat room, a robust style which is sensitive and is fair on the particular employees. So we're going to move on to our last slide, because we're just looking at the time. We're going to be coming to an end, and this slide is titled Rights from Day One. And I think we had a question concerning whether or not an individual has pretty much protection, particularly in a discrimination context, even if they've just started, it's their first week, they're on a probation period, for example. Do they have protection from harassment and from, I suppose, discrimination, whether it be direct or indirect? And we've covered the differences in those concepts in previous webinars, and you can go onto the Shorebird website and view those. But Paul Smith, I'll hand over to you. Do they have protection from day one?
In those regards, yes, they do. And in fact, they have protection before day one, because the Equality Act covers applicants for employment as well. You'll see the new poll that's just been put up on the screen regards excessive sickness absence. And we've asked whether or not, as a gauge of attitude, whether your business would never recruit someone with an excessive sickness absence record. What we see at the moment is, although it's fluctuating, a disagreement with that. And that's reassuring to see, although it's split about 3/4 to 1/4. Because bearing in mind, if you have a blanket policy of not recruiting people with excessive absence, particularly if the absence has come through stress or if they're a disabled person, without giving it any more thought, you're potentially going to have to objectively justify that in a public forum. And if thought hasn't been given to inquiring, for example, as to the reasons why someone was absent, what was it, if it was anything about their previous job that made them absent for so long, is there going to be any difference with the job they're doing for you, for example? It's those kinds of questions you need to be very, very careful about, lest you face a discrimination claim even before somebody is your employee. So with respect to the Equality Act claims, harassment, victimisation, direct and indirect discrimination, and reasonable adjustments, that duty kicks in from before day one, not from day one itself, but it continues through. The problem, of course, relates to unfair dismissal, which, unless it's for an automatic ground which negates the 2-year qualification period, then there is no express right to unfair dismissal protection. But of course, if you're dismissing someone because they're disabled, good luck in having an employment tribunal find that that isn't discriminatory. It's just a question of being very, very careful and knowing what protections there are.
Could I add something, Adam? I wondered whether the point of this question might be getting at, I think when I looked at the email question that I think came through, I think it was connected with the idea that someone might be on probation with their employer, and that's a very common situation. And I think what may have been an issue is that forgive a right not to be dismissed. I think the straightforward answer to that is that doesn't make any difference. I mean, first of all, a probationary period, unless it was worded very strangely, would not give any right to be for the employee to be treated as a fixed-term employee. But in any event, that employee would still be subject to the same qualifying period for accruing the right to bring an unfair dismissal claim.
You'll see there's a new poll there, but I think the answer's rather been given away by me. I apologise.
Absolutely. So what then do you think about if, for example, we have a factory job and it involves standing for 3 hours at a time on a 6-hour shift, for example, so you get a break after 3 hours, and there is a person who has done the job before for many years, but in their old job they've always had a stool, for example, and have been able to have breaks every hour, for example. But other employees job before, but they're as fit as a fiddle. Do you think in that circumstance an employer should simply opt for the ones who are fit and can just work the 3 hours, or the one that can have the stool and take the breaks? I suppose that comes into reasonable adjustments, doesn't it?
I think that's got to be right, Adam. It's a difficult one because I think Paul's quite right in saying that potential employees do have a right when it comes to the selection process not to be discriminated against. And I suppose the difficulty is that if that becomes a subject for discussion during the course of an interview or something, when someone's being recruited, you can see all sorts of problems arising if the employee somehow gets the understanding that the reason why they've been turned down, as it were, for employment is because of the perceived difficulty of accommodating the person's disability. So I think it's a very difficult issue, frankly. I suspect that behind the scenes, most employers are going to opt for the employees that they perceive will be able to do the job without any problems in terms of fitness.
Yeah, absolutely. Okay. Does anyone else have any specific questions on this subject? Because it's often quite daunting. I did a webinar, it's probably a couple of months ago now, isn't it? There's about the recruitment. I think it was actually about recruiting and what are the considerations you need to have when you are recruiting. So seek that out. It's on the website, and there were some interesting discussions had there. So before we end, do any of you have any specific questions that relating to whether it's rights from day one or any of the other topics we've covered today? Do feel free to put them in the chat box or any questions. And in the meantime, I'm going to ask Paul Wilson. You've put a crib sheet together for us of recent case developments. Could you pick one of those perhaps and just raise it? I see you've got the obesity one, the Kaltoff.
Well, yes. I mean, I can go. I imagine. Have I got a few minutes, Adam, just to run through this?
Yeah,
I think I can, because I think I can probably highlight what's happened over the last year in the field of disability fairly quickly. I'm not going to say a great deal about any of these issues, but just the really headlines. I mean, it may have come across your computer screens from a case called Kaltoft and the municipality of Billund. It's a Danish case that went through the European Court. That the European Court found that obesity may amount to a disability for the purpose of the framework directive. Now, I mean, really, when you think about it and you look at the definition of disability under the Equality Act, that's not at all surprising. I suppose it is controversial and it did hit the headline, so I mentioned that. Another case on a similar line really was the case of Metro Line Travel and Stout this year. It was an EAT case. Sorry, when I say this year, I mean last year, forgive me. And what that found rather surprisingly was that an employment tribunal had erred in finding that type 2 diabetes was a disability. And you'll all recollect that when you're assessing whether someone is disabled for the purpose of the Act, you're supposed to discount the effects of treatment. And the person in question had a diet regime whereby they avoided sugary foods. The tribunal and the EAT found that that was just a reasonable coping strategy. It didn't amount to a treatment, and therefore, if the reasonable coping strategy could minimise the effect of the impairment so that it was no longer substantial, the person would not be disabled. So that's an interesting one to bear in mind. Just running on, there have been some interesting cases last year about Section 15 liability under the Equality Act. And just to maybe highlight the one that I think is most interesting is this. What I find happening quite a bit in disability discrimination cases is that an employee will complain about an employer's efforts to put in place reasonable adjustments. And then they will make that the subject in their litigation of a Section 15 claim. Just to highlight what Section 15 is, what you're saying is that the employee's been treated unfavourably by reason of something arising from the disability. And there was an interesting case called Trustees of Swansea University Pension and Insurance Scheme versus Williams in the EAT, which basically is giving an indication that if you're complaining about the way reasonable adjustments are being implemented, that there are conceptual difficulties about that giving rise to liability under Section 15, because when you think about it, taking steps to make reasonable adjustments, in doing that, you're actually taking positive steps and putting the disabled employee at an advantage. So that simply couldn't be treating the argument would be the employee unfavourably. So it's a little bit difficult to explain, but I think it's a very interesting case. Moving on, I think just to pick out a few more cases which I think are really interesting in relation to disability. A lot of you will have absence management schemes whereby an employee can trigger management action after they've been off intermittently for a certain period of time. And one of the issues is that whether employers should make allowances and in effect discount disability-related absence. This is now a moot point. I think good practice would say you should. There's a case called Griffiths versus the Secretary of State for Work and Pensions last year, which is, in 2014, which is going on appeal, which suggests that an employer isn't under an obligation to make any discount for an employee's disability-related absence. So I think probably those are the most interesting cases over the last year, Adam. I hope that helps.
Yeah, no, that's really helpful, and we're just about out of time. Sarah, I've seen your question just in the questions box, and it's quite detailed. So what I propose to do, I've got your email address. I'm going to email you about that, and I'll canvass the view of the two Pauls. I'm saying it like they're a comedy double act over at Broadway.
We're definitely not a comedy double act.
But I'll canvass their views, and I'll drop you an email about that later on this afternoon. But thank you all for attending. I hope you found it useful. Our contact details, if you do have any other questions, are there on the screen. You can get us at employment@broadwayhouse.co.uk, and our telephone number's there as well. In terms of instructing us, most of you know that the way it works is you instruct solicitors to deal with your cases, and they instruct us to go along to the tribunal and represent employers and employees. And I think Paul Wilson and Paul Smith do direct access work as well. So if you have any questions, do drop them a question, do drop them a line, and we're available. It's a shameless plug. We're available to represent. Have wig, will travel. I think is the summary. So thank you to Liz as well for inviting us back to do this, and I hope you all found it useful.
Thank you
all
very
very
much.
much.
Thank you.
Thank you very much, Paul and Adam. I think my days of Dimbleby are completely useless. So you handled that all well yourself. There's no need for me, was there? Absolutely fabulous. Some really good feedback and some points and all sorts there. So hopefully that's given you all some food for thought and some ideas with which to take back to your businesses. Please get in touch with them directly. There are contact details there. And just to finish off in the last 20 seconds I've got, the couple of webinars that we're running next week. We've got the breakfast seminar, which will be all about energy in organisations, very appropriate for this time of year, and also appropriate for this time of year. We seem to be running quite appropriate ones. Will be the world of work and how that's changing in 2016 by Michael Millward. So please join us again then. Thank you very much. And as always, if you could leave your comments on the Pay Compliment website, that would be really appreciated, just to sort of get some good feedback to improve and for obviously for our own marketing purposes. So thank you everybody, and thank you Paul. Thank you Paul. Thank you Adam.
Thank you.
And we'll see you shortly.
Happy New Year to all.
Happy New Year.